Hello students, elections are considered to be the backbone of democracy, and one of the most fundamental requirement of election is right to vote. But right to vote is not considered as a fundamental right in India. Repeatedly, Supreme Court in its judgment have said that right to vote is a statutory right. It's not a fundamental right. In Anoop Baranwal case in 2023, Supreme Court have called it a constitutional right, but still not a fundamental right. Why is Supreme Court doing so? We are going to see that today. Along with it, we are going to see what and why the demands of making right to vote as a fundamental right has been arising from several quarters of the country, and the several judgments of the Supreme Court which are related to this particular issue of right to vote. Welcome to Shriram's IAS UPSC channel. My name is Bharati, and before I start, I would like to tell you about this free one-to-one mentorship of Shriram's IAS. If you are a UPSC aspirant and you have some kind of doubt in your preparation, the only thing which you have to do is to scan this QR code or go to the description, click the link, fill the form, and you can talk to our expert mentors. It's so easy to get guidance. Now, let us first discuss about the cases of the Supreme Court. What Supreme Court has categorized the right to vote into. The first of the major, most important cases has happened in 1952, NP Ponnuswami versus the returning officer. Now, in this particular case, the Supreme Court has called right to vote neither a common law right. It is neither a common law right nor any other kind of fundamental right, but rather a right given by the statute. That means it is a right given by the Parliament's action, by a legislation made by the Parliament. That is, Representation of People's Act 1951. If you look at section 62, clearly it is written the right to vote. But it is not a common law right, it is not a fundamental right. Now, what is this common law right? Common law right simply means that any kind of right which is made by the court. There can be fundamental right which is written under part 3rd of the Indian Constitution. Several rights are extended by the Parliament through statutes. And there are common law rights also given by the court. When the courts are delivering their judgments, through the process of justice, several rights can be interpreted. So, right to vote is neither a common law right nor a fundamental right, but a right created by statute. Now, that is what is said by the Supreme Court in 1952. And again, it has reiterated its position in 1982, Jyoti Basu case. What does it say? Right to elect, fundamental though it is to the democracy, it is very fundamental to the democracy, okay, is neither a fundamental right nor a common law right, but purely is a statutory right. Again, the same thing which has been said in NP Ponnuswami case. Now, in 2006, Kuldip Nayar case came up. Here also the Supreme Court reiterated the same position which it has taken in 1952. A constitution bench reiterated this position, holding that while democracy forms the basic part of the basic structure of the Indian Constitution, the individual right to vote flows from legislation. Again, the Representations of People's Act 1951 made by the Indian Parliament. Repeatedly, the Supreme Court is saying that it's a statutory right, it's not a fundamental right, neither it's a common law right, nor it's a constitutional right. Then in 2002, this particular Union of India versus Association of Democratic Reform, here also, the court held that the voters have the right to know the criminal background, the educational and the financial background. And this is covered under Article 19(1)(a). Can you imagine? Right to vote, Supreme Court is saying, is a statutory right. It is repeatedly saying that right to vote is not a common law right. It is neither a fundamental right. It's a statutory right. But every citizen's right to know about the background of a particular candidate who is fighting the election, that is considered to be a fundamental right under Article 19(1)(a). So this is something unique, and you will see another unique thing here in People's Union of Civil Liberties. It's a 2003 case where it says that right to vote is a statutory right. Again, the same thing. It is held that the freedom of voting, that is, the freedom to make an informed choice, is a fundamental right. Again, the right to vote is a statutory right. But the informed choice which you are trying to make, that flows from a fundamental right. It simply means that right to vote is still not a fundamental right, but your ability to make a choice of the best candidate possible, that flows from Article 19(1)(a), freedom of speech and expression. Now this is a NOTA judgment of 2013. Again, Supreme Court says, recognizing the option of none of the above to be flowing from Article 19(1)(a), none of the above. Again, your ability to reject all the candidate is again a fundamental right under Article 19(1)(a), freedom of speech and expression. Your ability to make an informed choice is a fundamental right. Your ability to know about the background of the candidate for which you are voting, that is also considered to be a fundamental right. But right to vote is not considered to be a fundamental right. It is a statutory right. You must be confused why Supreme Court is taking all these judgments, why the perspective of the Supreme Court is not changing over a period of time. We are going to discuss about it. Now comes the Anoop Baranwal case of 2023. Remember how the Election Commission of India and the posts of the Chief Election Commissioners and the other election commissioners and the elections to them have been changed through this particular judgment. And then the Supreme, after the judgment of the Supreme Court, the Parliament has also brought a particular act in which it made a committee consisting of the Prime Minister, the leader of opposition, and a cabinet minister to be appointed by the Prime Minister. That is the committee which is going to select the Chief Election Commissioner and other election commissioners. Earlier, this cabinet minister was not there. In its place, Chief Justice of India was there. This was the case, Anoop Baranwal case. But in this case also, repeatedly Supreme Court has said one thing which shows the change of perspective related to the right to vote. What was that? That repeatedly they are expressing it to be a constitutional right. Right to vote to be a constitutional right, not a fundamental right, but a constitutional right. Till now, the Supreme Court was saying it to be a statutory right, but here in Anoop Baranwal case, it repeatedly calls it a constitutional right. Now, in Kesavananda Bharati case, as you know, the case which has established the basic structure in the Indian Constitution, this particular mechanism, the court has repeatedly held that democracy forms the part of Constitution's basic structure. Now, for democracy, voting is very much required, but right to vote is a statutory right or a constitutional right, not a fundamental right. Why? That is the question. In Indira Nehru, Gandhi versus Raj Narayan case of 1975, court said that the court underscored that free and fair elections are essential feature of democracy. Again, when democracy is so important and democracy is the basic feature of the Indian Constitution, why not allow the right to vote to be a fundamental right? Let's understand the logic first. See, Supreme Court is not declaring it to be a fundamental right, not because Supreme Court thinks that right to vote is not important. That's not the point. But historically, if you see, not only in India, in other major democracies also, if you see, right to vote is not considered to be a fundamental right. Rather, the regulations and the law related to voting are made by the Parliament. Multiple regulations are made when it comes to election. Regulations may change over a period of time. If it is declared to be a fundamental right, then the Parliament's power versus the court's power, that balance which is created will not be there. Parliament has the power to make regulation over the elections. Parliament will, in one or the other way, lose that power. Every change which is made by the Parliament will be then challenged in the Supreme Court. Why? Because right to vote is now a fundamental right. Earlier, if there were several disputes, you can go to the High Court by filing a petition, an election petition under the Representations of the People's Act 1951. But if right to vote is declared as a fundamental right, then under Article 32 and under Article 226, you can approach to the Supreme Court and the High Courts respectively. Then this particular election petition clause will be, it will be redundant, it will be of no use. The power of the Parliament to regulate the election, that is one of the most important elements here. And if it is declared as a fundamental right, right to vote, every little thing, whether to include a name in the SIR or to exclude the name from the SIR, at what time the election should begin, at what time the election should end, the regulations related with booth control and other things, everything can be challenged in the Supreme Court directly. Now, that will create a huge mess for the Supreme Court. And also for the process of election, because the election has to be conducted, the process will be halted totally if repeated petitions will go to the Supreme Court because of the infringement of one of the fundamental right. That is when the Supreme Court declares or interprets right to vote to be one of the fundamental right. But that is the reason why it is not doing. But there have been a demand why voting should be recognized as a fundamental right. There has been demand, and why that demand has come up, because Supreme Court has already recognized several of the associated rights of the right to vote to be fundamental rights, such as we have already seen, right to know about the candidate, the criminal background of the candidate, the financial background of the candidate, and educational background of the candidate. It is the right of a citizen to know all these things. At the same time, freedom to make informed electoral choice flows from 19(1)(a), right to freedom of speech and expression. Secrecy of the ballot, again flowing from 19(1)(a). Right to reject the NOTA judgment, again flowing from 19(1)(a). Right to freedom of speech and expression. When all these can be declared as fundamental rights, then what is the problem in declaring right to vote to be fundamental right? I already told you, but these are the judgments, and these are the, these are the judgments of the Supreme Court, and these are the points which are raised by several people who want to see right to vote to be a fundamental right. Then democracy begins with votes. Vote is the very instrumental thing. If you cannot declare right to vote to be a fundamental right, then what is the meaning of democracy? Similarly, democracy is the part of the basic structure. Hence, right to vote has to be basic structure, has to be the part 3rd of the Indian Constitution. Democracy without votes is inconceivable. And then they also say that under Article 326, the right to vote has been allowed, hence making it a constitutional right. But if you closely see Article 326, it talks about the universal adult franchise, and it also says the regulations made by the Parliament are important in this matter. I hope you are getting this. Exclusion from electoral rolls affects the constitutional guarantee, which has been happening in SIR. Multiple lakhs of people have been excluded from the electoral roll. If it would have been a fundamental right, doing SIR exercise would be very difficult. Very, very difficult. Purification of rolls, that is one of the major fundamental duty of the Election Commission of India, and if right to vote is recognized as a fundamental right, then it will be very difficult to purify the electoral rolls. But these are the arguments which have been made by the people who want right to vote to be included under Part 3rd of the Indian Constitution. Anyway, what do they say? They are not saying that every little rule made for election has to be declared as a fundamental right. They are not saying that. The core right, they are talking about the core right to vote, the core right every eligible voter and citizen to participate in the democratic process. That is what they want to be included under Part 3, to be made a fundamental right. Parliament can still go and regulate the age requirement, qualification, disqualification, procedures, other things. But that fundamental core thing, that a person's right to vote to be recognized as a fundamental right, is what is the demand of many people coming from many quarters in the country. So that is it. That was the issue. The fight between the parliament on one hand and judiciary on the other hand. The judiciary's wisdom to keep a balance between the rights it has, the powers it has over the power parliament has. And the mess it can create by declaring right to vote to be a fundamental right. Every little regulation and rule which is made can be directly challenged under the Article 32 in the Supreme Court of India. It will create a total mess. So thank you very much for joining me. If you have any kind of doubt, you can ask me on the comment section. Thank you very much for joining me. Have a nice day. Jai Hind.